Welcome to Thursday night. Hey y'all, John Skiba here from the Consumer Warrior YouTube channel. It's Thursday night. We're back here in January of 2023, brand new year. Missed the last couple of weeks traveling with family for the holidays. I hope you all had a great holiday season. Hopefully got a little bit of time off, a little bit of hopefully not focusing and stressing on all these types of things that we deal with here, which are debt collection lawsuits, wage garnishments, bankruptcy, all that kind of stuff. So we're back here. If you're new to the channel, each and every Thursday night, I try to do a live stream where we go over questions. We discuss strategies on dealing with debt collection lawsuits, all that kind of stuff. The way that we do it is if you're watching on YouTube, you can put in the chat section and I'll actually put it up here on the screen and we'll go over it and discuss it. My disclaimer that I give each and every week is that while I am a licensed attorney in the state of Arizona, I am not licensed anywhere else. And so this should not be considered legal advice. This doesn't create any attorney-client relationship. If you need that, I highly recommend you contact an attorney in your state. Most attorneys do free consultations with these types of practice areas, and you can discuss that and get some actual legal advice. This is just some dude talking on YouTube, so take that for what it's worth. All right, so I was going through some of the comments online, and something that I found kind of interesting is a couple of comments. Let me see where they're at. First one here. Now, we're going to, ignoring this user's name, we'll just call this person King. But he says, once you're served with the debt collection lawsuit from Bank of America, are you able to call them and negotiate a settlement and possibly drop the lawsuit? Or has that window closed? So that is a great question from my man King here. That is, if the lawsuit has actually been filed, yes, you can still reach out, but I should say this. So in his question, Bank of America was the one who filed the lawsuit. You're going to have to reach out to Bank of America's attorneys, the ones that filed the lawsuit. You're not going to be able to reach out to Bank of America directly. If you do, they're going to come back and they're going to say, we have counsel on this now. You need to go through the attorneys, which delays things and makes it a little bit more complicated, but you can still reach out to them. And I always recommend, if you're going to, particularly if it's an original creditor lawsuit, reach out to them before you file the answer. In most states, you have 20 to 30 days before that's required. You can reach out to them and just say, hey, I'd like to try to resolve this and maybe propose a settlement offer to them. And there's no harm in doing that. The reason why is because in civil cases, under the rules of evidence, Rule 408 in most states, it states that settlement negotiations are not admissible in the case. The idea behind it is they want the parties to be open and to negotiate and to resolve the dispute rather than litigate it. And so if you call up Bank of America and you say, hey, I'll pay you $2,000 and let's just have this thing be over with, they can't then run into the judge and say, oh, look, they offered $2,000. Clearly they owe the whole thing. They can't do that. So there's no real harm in doing it. I don't usually recommend giving up a lot of financial information. You don't want to give up bank statements, pay stubs, anything like that. But at the same point, there's no harm in reaching out and trying to settle it. And if you do settle it with their attorneys, then yes, they'll just dismiss the lawsuit and will be as if it never happened. So that was a good question from the King there. This other question said, this one's a little more family friendly. Jeep TJ Whelan said, I was told by a local lawyer to file a Chapter 13 bankruptcy, but that does not work for me since I'm going through serious financial hardship. So Chapter 13 is where you have to pay some of the debts back. Says I must file a Chapter 7. My mortgage company said I can keep my house so long as I'm making my regular payments. But I have a pending security clearance government job that can take up to another year to be completed. I've heard mixed thoughts on this. I want to know your thoughts on it. Well, initially, yes, I agree with your mortgage lender that if you need to file for bankruptcy, whether it's Chapter 13 or Chapter 7, as long as you're making the payments and you're current on those, you're going to be able to keep the house, assuming that you don't have equity above and beyond the homestead exemption in your state if you're filing a Chapter 7. So, and you calculate your equity by taking the value of the home, subtracting any mortgages, liens, anything like that against it. And so, for example, if your house is if it's worth $500,000, and you owe $300,000 on it, you have $200,000 of equity. As long as you don't have equity above and beyond what the homestead exemption protects in your state, you can keep the house as long as you keep the payments current. So that's not a problem. The second part of your question, though, relates to, you said you have a pending security clearance for a government job that can take up to another year to be completed. That can be a little bit more tricky. Bankruptcy in general, I don't see it impacting employment. However, here in Arizona, I have filed bankruptcy for like Border Patrol agents. That becomes an issue if you have any type of security clearance in a government type job. That does, and it's kind of a little bit of a catch-22, because the other thing that can impact those jobs is if you have a bunch of debts that are delinquent or charged off and they're in your credit report, because that looks like you have all these loose ends out there and it's not dealt with. However, if you file the bankruptcy, that deals with all the loose ends, but then at the same time, you're in a situation where now you have a bankruptcy on your record. My recommendation is you talk to the HR people and just kind of be open with it. I've actually had situations with clients who have needed to file for bankruptcy, and they go to the employer, the government, the state, the county, whatever it is, and they say, hey, look, it's better that you go through the bankruptcy, get that done with, and then you can come on, because then we know that everything's, there's no loose ends out there that are going to cause problems. So those are things to take a look at. So, all right, let's jump into some of the questions here. Matt Strong. That is strong. Thank you for supporting the channel today. I appreciate that. Let's go over your question. Original creditor charges off. Got to make sure I got all your question. Okay. Original creditor charges off an account and sends a 1099-C with a G code. Can they then sell that same account to a debt buyer, but also try and collect on that account and send another 1099-C? So the charge off, which happens 6 months, it happens 180 days after there's no payment, like on a credit card. The creditor isn't required to charge it off. And yes, they can issue the 1099-C. The thing with 1099-Cs is they can be amended or altered or changed even after the fact. So if they charge off the debt, they can even still try to collect on it. So let's say it's like American Express, Discover, who tend to keep their own debts. They can charge it off because they're required to do so. But at the same point, they can still try to collect on it. And then if they get money from you, then they're supposed to amend that 1099-C. Whether they do that or not, I don't see a lot of those. I see a lot. And I can tell you something that is interesting. This is kind of a side thought. Early on in my career, every January, I would get a big stack of 1099-Cs for accounts that we had settled with people over the years. It's also important to know if you file bankruptcy, there is no 1099-C. The 1099-C is only given if the creditor forgives a certain amount. So there's some type of settlement involved. Whereas in bankruptcy, the court makes a legal distinction between a debt that's forgiven in settlement or legally discharged under the bankruptcy code. So there's no 1099-C in a bankruptcy. But I used to get a big stack of them from all the debt buyers. They would send those out. I haven't received a big stack of 1099-Cs in 6 or 7 years. So I don't know if they're actually going to send those out. But the short answer is yes. They can charge it off, do the 1099-C. They can even sell it to a third-party junk debt buyer. And then later on, they could amend that if there's monies that are received. So yes, they can do that. So, all right, Alex, one of our regulars. Appreciate that. Talk about appealing judgments from justice to superior court. And as always, there's a shout out from Yuma, Arizona, which I appreciate. So in Arizona, where I practice law, how the courts are broken down is the justice courts deal with anything that's under $10,000. The superior court deals with anything that's over $10,000. And then there's the Court of Appeals. They take appeals from the Superior Court. And then there's this Arizona Supreme Court who deals with appeals from the Court of Appeals. But if you're in the Justice Court, where you have a justice of the peace hearing your case, the appeals go from the Justice Court up to the Superior Court judges to take a look at. So they're different than if you're appealing a case from the Superior Court. Now, something that's important to know in Justice Court in the state of Arizona, if you get a final judgment against you and you want to appeal it to the Superior Court, the window is very, very limited. It's 14 days, 14 calendar days from the day that the judge signs that judgment. I can tell you where problems, you need to be on top of this, because where I've seen problems come into play is sometimes the judge will sign it, put it on their desk. Judge takes it over to the clerk. The clerk does whatever they do. They mail it out like a week later, and you have a very short window to actually file your notice of appeal. And when it comes to appealing a judgment, whether it's from the justice to superior to the Court of Appeals, it's one of those drop dead dates. You miss it, you're done. You miss it by 1 day, you miss it by 1 hour, you're done. So you got to get the notice of appeal in. And so you got that 14-day window. There's very limited documentation required to appeal. You file a notice of appeal, and there is on the Arizona Judiciary's website a packet that people who are self-represented can download. But the notice of appeal, you're just letting the court know, hey, I'm appealing. You have to put what judgment it is, the case number, all that kind of stuff. And then once you, they also have something called a designation of the record, where you're stating which documents. Essentially, you got to think of it this way: you're giving instructions to the clerk of the court in the justice courts of what packet they need to send over to the superior court. So there's the justice court will then take that. You may have to pay a cost bond. It's usually about $250, where they take that, they hold on to that. In the event that you win your appeal, that'll be reimbursed to you. If you lose the appeal, they're going to give it to the other side. It then gets transferred to the superior court. Now, your opening memorandum, your argument, because there's no retrial, it's just you're submitting a brief. That's due 60 days from the day that the notice of appeal was due. So you have roughly 2 months to put all that together. You're also going to have to pay a filing fee with the justice court, and then the superior court is going to stick it to you as well. They're going to require that you pay a fee. I believe it's $245. And then both sides are going to submit their briefs, and then the court will issue they'll issue what do you call it? They'll issue a ruling, and they issue a written ruling. And I can tell you, I've appealed a number of cases from the justice court. Only one time has there been oral argument, so you're likely not going to get that. It's also different than if you appeal to the Court of Appeals. Some of you have seen on my YouTube channel, I was involved with an appeal with Midland Funding before the Arizona Court of Appeals, and it was a 3-judge panel. When you go to the superior court, it's going to be a 1-judge. It's actually going to be a commissioner who's assigned to handle appeals. So, all right. So that's pretty much how that process works. And then you'll get a ruling. And I'm going to tell you this, Alex, it takes forever. Whether it's from the justice to the superior court, the appeals take, and they add another year onto the entire process. So hopefully that is helpful. All right. Simply Credit. Can a credit card report late payments after the account is closed? Well, they can still, the information, if there's been payments that were there recently, they can. And yes, if the payment, I guess it depends on what you're meaning by closed. If the account is closed as far as you can no longer use it, and it's been charged off, the charge off should signal that they can no longer report payments, because that's essentially cutting it off, that they've said that they're not trying to collect on it anymore. And then, so they shouldn't be hitting you each and every month, but it will show as a charge off on your account. If there's anything you think is not accurate, it is something you can submit a dispute. It's a prerequisite if you want to sue under the Fair Credit Reporting Act. So I always recommend people take that action in the beginning. All right, let's see what else we have right here. CR 5.0 newbie says, I'm on my 4th arbitration with Midland. They do not learn. The previous 3 were dismissed with prejudice. Nice job. Part of why they don't learn is part of it's just understanding and seeing kind of the machine that is debt buyer litigation. Most collection firms have relatively few attorneys, usually anywhere from 2 to a handful, and they process thousands of cases. And if you look, they have like a hot docs kind of thing where they're just changing the names and the numbers out. I mean, these aren't, and this is where the debt buyers get in trouble. If you look at like the Consumer Financial Protection Bureau, some of their consent orders against them, they just produce these things in giant volume. The big debt buyers file over 500,000 lawsuits a year. And so there's no way that they're putting the attention that, if you had like a real estate dispute or something like that into it. So Monica says, thank you. You've really given me the strength to fight back. Appreciate you. Thank you, Monica, for supporting the channel. All right, let's see here. Randall, one of our regulars as well, part of our Consumer Wire community. Got to watch your new deposition course today, driving from Florida to Atlanta, top shelf. Thank you for putting that together. Very powerful. Thank you for supporting that. And I'll put a link down in the bottom if you want to become part of our Consumer Warrior community. I do have some trainings and tutorials that I don't provide on the YouTube channel where we go into kind of advanced level lawyering type stuff. So I appreciate, Randall, for you bringing that up. So, all right, let's see here what 1P4G says. If Synchrony Bank hires Roush Sturm to collect and sue for a credit card debt, does Roush need to follow the FDCPA? I heard the original creditor does not, but Roush Sturm is not the original. That's a really good question. Something that's so bizarre to me about the FDCPA, the Fair Debt Collection Practices Act, is that it does not apply to original creditors, as 1P4G has said here, which is kind of weird if you think about it. So, basically debt collectors, they have to be careful of what they do, but it's open season for other just original creditors, and it kind of is. You also ought to look, though, each state sometimes has their own version of the FDCPA. Like Arizona has one. It doesn't have quite the teeth that the federal one does, but it's more broad as far as who it can be brought against. But the case law out there is that the FDCPA does apply to those who are primarily in the business of debt collection. So if a company like Roush, they file a lot of debt collection lawsuits, I think there's a very strong argument that those attorneys are subject to the FDCPA, even if their client is not. So, all right, let's see here. We got Salmonella, former client. Thanks, Sal. Handling your case with efficiency and professionalism. You're definitely the real deal. I appreciate that. I try to be the real deal. I wish I practiced in California too. I need to broaden my scope here. So, all right, let's see here. See what Monica has to say. I filed a motion to compel arbitration. Chase has now filed arbitration. I don't want to pay the consumer amount of $200. Can I just let that work itself out? If you don't respond, you do run the risk of a default. My recommendation would be to file the response. Because if they're willing to pay the fee and move forward with it, because like I said, the fees for them are very large. And so part of it may depend on how much they're suing you for, but you're going to pay a filing fee, whether it's in the court or whether it's in arbitration. I would recommend paying it so you don't run the risk of any kind of default there. And if you don't participate in arbitration, then they're going to probably just bounce it back to court anyway. So I would recommend you do that. So, all right. And you know what? This question goes right along there. Says, what should be the next step if the court granted the motion to place a 60-day hold to give the defendant time to file for arbitration after the defendant filed a motion to dismiss? So that's a great question that we get quite a bit. And what I recommend is that there's two options. One is you could file it. I did that just recently on a case. I went in with the AAA. I went and filed my own arbitration. And then I also, once I did that, I filed a notice with the court saying, hey, I did it. We filed arbitration. We did have to pay, the $200 filing fee, and we'll see if the other side, if the creditor is even going to pursue us and follow through there, or if they're not. But that would be one step. Another step is to wait, 45 days. And if it does, or even the full 60 days, if the creditor doesn't pursue it, then you could file a motion to dismiss with the court and ask them to dismiss with prejudice, telling them that they didn't pursue it. My argument is always, like I've said it before, is that I don't, it's weird to me, and even though I just did it, it's weird that the consumer is initiating the arbitration. You didn't sue, you didn't sue them. They sued you. They're the ones with the claims. If they want to sue you, then they should be the ones initiating it. And so I think there's a strong argument to say, hey, I'm going to file a motion to dismiss, and because they didn't pursue the arbitration like the court had ordered. Look at your arbitration clause really closely. There are some of them out there that do require, and they even say in there that we will initiate it. If you elect arbitration, then we'll be the ones to initiate it, we being the creditor. So I would take a look at that closely, because if you have that, then you're going to be golden. All right, let's talk bankruptcy question. What's the next step after the 341 meeting? So whether you file Chapter 7 or Chapter 13 bankruptcy, about 5 weeks after you file the case, there's something called the meeting of creditors. The shorthand for it is 341. 341 is the bankruptcy code section that authorizes and requires these meetings. So attorneys call it the 341 meeting. This is the meeting with the trustee where they put you under oath, ask you if what you've submitted to the court is accurate and any specific follow-up questions. It's literally about a 5-minute meeting. Something nice is post-COVID, we used to have to go down to the courthouse. I was telling my wife the other day, was something that's so bizarre. I used to be at the bankruptcy court 3 to 5 times a week between hearings, 341 meetings. I haven't been to the bankruptcy court since January 2020. So 3 years now without going to the bankruptcy court, and still filed, over 1,000 bankruptcies during that time. But it's just COVID changed things, and now these meetings are all done telephonically or through a Zoom conference. The next step in a Chapter 7 case is, for most cases, that's really it. There's no other hearings. You do have a second financial management class that you have to take online. It's like a 1-hour video thing you have to watch. And then the court will enter the discharge order, which is the final order from your judge saying your case is over. And it will... it'll discharge out 60 days, usually after the meeting of creditors, sometimes a little longer. If you're in a Chapter 13, at this point, you're already making your monthly payments and your plan has to be confirmed. Depending on the jurisdiction you're in, that could be very quick. If you're in Arizona, it takes a while. But then it's really just moving towards plan confirmation. So, all right, let's see. Let's see what Mark has to say. Sued by Guglielmo and Associates, MidFirst Bank. I filed a motion to dismiss and compel arbitration. They filed a motion to stay the case for 30 days so the defendant can initiate arbitration. Judge granted the motion. So like I said, you're fine to do that or wait the time period. I'm kind of dealing with both. And part of it is part of the justice court system in Arizona. I always say it's kind of the wild, wild west of law. The judges they're elected, they're different backgrounds, very few of them are attorneys. And they're kind of like their own little kingdoms, that there's not as much predictability in those courts as maybe like the Superior Court. So it's kind of, touch and base as far as what you try different things. I mean, if you're dealing with it yourself, I guess I have the luxury of trying different things to see which things are most effective at different courts, but that's kind of what you do. So, hey, 5.0 brings up a great point. Arbitration does work better on debts that are lower, just because the filing, if they're suing you for $2,500 and the filing fee is $2,000, it's gonna be a lot more effective strategy than if they're suing you for $50,000. Then they may be willing to do it. So let's see what Simply Credit has to say. Can I use the OG credit arbitration agreement to take Simply Credit? You got to help me with these abbreviations. To take the debt collector to arbitration. Yes. Well, you need to use the original credit arbitration clause. Absolutely. And you can get a copy of those. It's in the terms and conditions of the credit card. If you go to the Consumer Financial Protection Bureau's website, they have a database of most credit card agreements where you could get that. If they haven't provided that to you, that's a place you can go and take a look there. All right, let's see what Kim has to say. Hello, I hope you had a wonderful holiday season. I did. I was served on December 22nd by a debt collection agency. I contacted the attorneys and we reached a settlement amount I was comfortable with. I was wondering if there's any way that I'm still at risk of them not actually dropping the lawsuit against me if I pay the amount we agreed to. They said the lawsuit won't officially be dropped until they receive payment. If I need to file an answer, the deadline is next Wednesday. So I just want to make sure I'm not making a mistake. So, you can understand it from their point of view. They're not going to dismiss unless you actually make the payment. And Kim, I don't know if you're in Arizona. If you're in Arizona, there's actually a 2-part process before they can default you. So in Arizona, it goes 20 days. If you don't file a response, then the creditor has to file an application for entry of default and mail a copy to you. And you have then 10 business days to file an answer to the lawsuit. It's kind of the court's way of saying, are you sure you don't want to respond to this? Because if you don't file a response within those 10 business days, then you're going to have the default judgment entered against you. So if you're not in Arizona, you got to be more careful, because some states and like the federal courts, you miss it, default's entered automatically and you're done. So what you could do is you could request an extension from the creditor. You could reach out to them and say, hey, look, I provided you the payment. You're providing the payment. And at that point, I need some assurance that we're still going to have this dismissed. I can tell you this, if you made the settlement and then they tried to pursue a default judgment against you, one, you'd have a strong basis to have that set aside. And two, I believe there's an argument there even for maybe an FDCPA violation if they're misrepresenting that to you. So that's my 2 bits on it. So Simply Credit, no problem. I didn't realize you're keeping it to 50 characters, but I appreciate that. We got it all figured out, but I appreciate you supporting the channel today. All right, that's going to do it for today. I've got a wedding I got to run to, so not mine, but friends of ours we got to get to. So, hey, I appreciate y'all checking in. I do hope you had a great holiday. I'll put a link here in the notes if you want to check out our Consumer Warrior community, or if you're looking for some of the tutorials. We put out a lot. I've got some more coming in the near future. With that being said, we'll catch you